Thank you for everyone who's joining this, either watching it right now or later on. Today, we're going to be talking about how to handle termination and retaliation issues. So this is specifically more geared towards employers, obviously, specifically here in Washington State, but applicable outside of the state as well. If you have employees in other states, there might be some more state-specific laws in your area. But this is pretty just generalized information about termination and retaliation issues. So things we're going to be talking about, I'll cover a couple of tips on how to prepare for terminating an employee, some things you should do to prepare beforehand, and things to do during. And then we'll talk about how retaliations lawsuits work in general and some things that you can do to help avoid them or at least mitigate the cost of them. So the first thing and most important thing to always remember is that Washington is an at-will employment state. This just means that you can fire an employee for any reason as long as it's not discriminatory, and an employee can quit for any reason. So an employee could be fired on a Monday afternoon because they wore a red shirt. You could just decide that they're not a good fit for your company or whatever, and you're allowed to fire them. Just you got to make sure that you're not firing them because of any sort of discriminatory reason. And that's where employers get really nervous. And the most popular thing that happens, as we'll talk about in a minute, is a retaliation suit. But if you are planning on terminating an employee, it's an unfortunate part of running a business, but it's going to happen to any business owner. You're likely going to have a situation at some point during your running your business where some employee will not be a good fit or will be dragging your team down for whatever reason. Here's some helpful tips that will help make the termination process run a lot smoother. The first thing, and this should go without saying, is clear communication. And this is both during the termination process and before the termination process as well. You need to make sure that your employees know what is expected of them first and foremost. Don't tell employees things like "we expect you to work hard and be a good employee." Those aren't measurable terms, and then no employee knows what working hard and being a good employee looks like from your perspective. So give them measurable goals that you can help them understand. And if you do so, then they have a much better opportunity, at least, to understand what's expected of them. And it should be much more clear to them when they're underperforming or if they're on track for termination. And then secondly, if they are underperforming or they're not meeting any sort of your expectations or standards, sit down and have a chat with them or send them an email or run through whatever communication process your company does to make that expressly clear to them. They need to understand what's expected, and if they're not meeting it at any point during their employment with you. And second, this is probably even more important, is document everything. If you talk to an employee about anything, make sure you sit down and take a minute to write something down that explains what you guys talked about. Far too often in employment lawsuits or discrimination lawsuits or retaliation lawsuits, what happens is an employee will get terminated and it turns into a big battle of he said, she said. The manager says, no, I told them several times that they weren't meeting these performance goals. And the employee says, no, they never told me that. They told me this. And that happened. And you're talking about something that happened years ago. And people forget things. People omit details that could have saved you tens of thousands of dollars. And a he said, she said battle, frankly, doesn't really work out usually very well for the employer side. So if you're an employer, it's important to know that if you're telling an employee something in person, if you have a meeting with them in person or over the phone or Zoom or however you do it, make sure you take the time to write a memo, a brief one. You can just say, I talked to John Doe on blank date about his performance goals. He's not meeting X, Y, and Z goals, and we want to increase those. John said he would increase those. End of story. But those documents are crucial in a retaliation lawsuit. They can be the thing that prevents you from having to spend $200,000 in a settlement versus versus $10,000 in a settlement, or even no lawsuit at all. It could be the thing that prevents them from even bringing a lawsuit. So document everything. Every time you talk to an employee, every time you have a performance meeting with them, make sure there's some documentation that explains what was discussed in that meeting, and you can have it in a place where you can reference it if you need it in the years to come, if that employee ever gets terminated. And then this one is for in the actual termination process, when you finally sit down to meet that employee and let them know that they're not going to be working with you any longer. make sure that you have an HR representative with you, or if you don't have an HR representative, upper level management, some other person in the room with you when you're firing the employee. It helps to have that person there as a backup witness, someone to corroborate your testimony that the employee, freaked out and punched a wall, or what you said if the manager goes off the rails and says something totally crazy, or you want someone to be there to make sure the manager doesn't go off the rails and say something crazy. It's important to have somebody else there that can corroborate what was said during the meeting. And then don't rush the process. Far too often, I get calls from employers that are saying, they'll call and say, I want to terminate this employee in the next hour. Is this okay? And they haven't done really any sort of these checklist items. They don't have any documentation. They haven't really thought through any of the other issues. They just know that you have a problematic employee and you want to get rid of them and you want to do it now. So, and I can understand that completely. If you've decided that you have a problematic employee or someone who's underperforming, somebody maybe who's bringing your team down, maybe they're a really toxic environment in your culture. I can understand the need from the employer's perspective to go, we got to get rid of this person. It's got to happen soon, but don't rush the process. Rushing through that process and not taking the moment to think about if you have the proper documentation, what your reasons are for termination, your risk of a lawsuit. If you don't take the time to think about these sort of things before you fire that employee, it's oftentimes those situations where you're going to get bit in the butt with a lawsuit later on. So don't rush the process. Take the time to figure it out. We'll talk about some checklist items to run through before you end up firing an employee. But make sure that you take the time to actually sit down and figure that out and assess what the termination process will look like. And talk to an attorney, of course. Don't let it come as a surprise to the employee either. It shouldn't, this is more of a summary of number one, I think, but it really shouldn't come as a surprise to the employee. If it's coming, if you think that his employee is going to be shocked by that they're being fired, then take extra time to sit down and talk to an attorney and look at all your documents, make sure you have everything figured out. But if you've done everything well, the employee shouldn't be surprised by the fact that they're getting fired. If you've been clearly communicating what your goals and what your expectations are for them as an employee throughout their employment, and you've been telling them over and over again that they're not meeting their goals or they're on track for termination, then it shouldn't come as a surprise to them when you actually finally sit down with them to tell them that they're being let go or they're being fired. And so don't let it come as a surprise. If an employee is shocked that they're being fired, call an attorney, call me, because that's oftentimes when you have a lawsuit or potential for a lawsuit. So retaliation lawsuits, I'd love to talk about every single type of lawsuit that an employee could bring, but we don't have that much time, nor does anyone have that sort of attention span. But retaliation lawsuits specifically are the most common type of workplace discrimination lawsuit that gets brought up. And in short, what a retaliation lawsuit is, in essence, is an employee claiming, hey, I did some sort of protected activity. I engaged in some sort of activity that our justice system has deemed protected. And you, employer, gave me some sort of unfavorable treatment because of it. Now, sorry there, accidentally clicked back. Now that doesn't mean that an employee doesn't have to be fired for there to be a retaliation lawsuit. It's just any sort of adverse impact on that employee. And we'll talk about what the elements are right here. So in order to prove that an employee has suffered retaliation, an employee has to show three things. They have to show first that they engaged in some sort of protected activity. And we'll talk about a few examples of what those are. Second, they need to show that their employer took a materially adverse employment action against them. So not just firing. And then third, they have to show that the protected activity and the adverse job action are causally connected, meaning that they're related to each other. They're not just two offhanded instances. So what are some protected activities? We've got a couple here. This is not an exhaustive list of every single protected activity that there is. There are, others that you come up with, but this encompasses some of the most popular ones. So, participating in employment violation investigation or lawsuit. So if an employee acts as a witness in a case against you, you can't discriminate against them for that or fire them. reporting, a lot of the issues come from these reporting issues. Reporting discrimination, reporting harassment are among the most popular. Refusing to follow any sort of discriminatory orders, asking for salary information, specifically to prevent compensation discrimination, refusing sexual advances, reporting safety or their health violations, and acting as a whistleblower. So again, reporting is definitely one of the most popular reasons that an employee will bring a retaliation lawsuit, and one of the more popular protected activities. So then what is an adverse action? I've hinted at the fact that it's not just firing, and that's true. It is really any action that would dissuade an employee from bringing these protected activities. In short, if the employee suffers any sort of negative job impact from them having for engaging in these protected activities, that counts as an adverse action. So think about things like, not just firing is obviously the big one. If they're fired, that's obviously an adverse action, but things like being demoted, or maybe a formal job performance warning if it's specifically related to them being engaged in it in a protected activity. So as a hypothetical, let's say John Doe reports some workplace safety violations, and because he did that, another manager sits down with him and gives him a formal warning that if he continues to report such activities, he could be terminated. That would be an adverse action, because now he's suffering some negative consequences because of a protected activity. Now, those two are pretty straightforward and usually not the sticking point in these lawsuits. It's usually this third one that kind of makes or breaks the lawsuit, and is a little bit more amorphous. So a causal connection, and this is just the employee needs to show that there's some sort of link between their protected activity and the adverse impact that they had. So they need to show, hey, I did this protected thing and then the bad thing happened. And they need to show some sort of link between the two. And usually that link is timing. So if the employee can say, hey, I reported this activity, and then right after that, a week later, the employer said, you're fired, then there's probably a good causal connection. They can show that the protected activity happened, short time after that, adverse impact. And so one of the things you can do as an employer is make sure that there's not a short timing in between these two. So let's talk about a hypothetical scenario. Let's say you've got an employee who's problematic, and this is a sticky situation to be as an employer. Let's say you have a problematic employee. John Doe is underperforming and has been for some time. You have some documentation, not as much as you should, but you have some documentation saying that he's been underperforming and not meeting certain goals. And then you're getting ready to fire John. You have a plan to fire John, say next week. Management has met and they've decided that John's no longer performing, he's not improving at all, and he's not going to improve, so we're going to fire him next week on Monday. Then on Friday, John reports some workplace safety violations or sexual harassment or any other form of harassment at work. Now, you as an employer should stop right there and before you fire him. And most of the time, employers here will go, well, we have good cause. We're not firing him because he's reporting this. We were already planning on firing him because he is underperforming, and we have some documentation to show that he's underperforming. But regardless, John has now reported something that's a protected activity, and you're planning on firing him within a day or two after he's reported this. Regardless of the fact that you're correct, that he's underperforming, you have grounds to terminate him because he's underperforming, and you're not terminating him because he's reporting this. You're terminating him because he's a bad employee. But if you terminate him shortly thereafter, your risk of losing the lawsuit being brought and losing a lawsuit goes up significantly. It's much, much, much harder now for you as an employer to show that he wasn't terminated because of that activity. You need a lot more evidence to show that he was terminated because he was a bad employee. So what should you do as an employer? You should wait. Now you know that if he can show that there's a close time between the protected activity and the causal or the adverse impact, then he's got a good case on his hands. And so what you need to do as an employer is, if he's reported something right before you were planning on firing him, just wait. Draw out that causal connection. Make sure that during that process, if he continues to underperform, you continue to document it. And how long should you wait? is another great question. That kind of varies between states, and different states and jurisdictions have different laws or precedents set about how long is too long, or how long is short enough before you can fire an employee. But essentially, it boils down, a safe answer is probably about 6 weeks. And that, again, that does not guarantee that every jurisdiction, or that will prevent you from any lawsuit ever. If you wait 6 weeks, it's not a hard deadline, but 6 weeks appears to be, at least in most jurisdictions, a time frame in which a lot of courts will agree that there's not a good case for a causal connection. So if an employee reported something and then you wait about 6 weeks and then you fire them after that, you're probably going to be okay, at least for the purposes of showing that there's not a causal connection between the protected activity and the termination, at least for on the timing grounds. Sorry, that was a lot of information, maybe a little too confusing. But long story short, if an employee reports something, don't fire them immediately. I know it's painful to have to deal with them even longer, but your safest option is to wait and try and terminate them later. And that's because these lawsuits are incredibly expensive. On average, out-of-court settlements for employment discrimination or retaliations cases can be upwards of $50,000, and that's if they're settling early. These cases can cost well above into the hundreds of thousands of dollars and can drag on for years, especially if you're going through with trial. And while 6 weeks may seem like a long time to hang on to an underperforming employee, it's certainly a lot less than a couple years dealing with them suing you and paying tens and hundreds of thousands of dollars to them after they've been terminated. So just first talk to an attorney, and second of all, don't rush into it. Take your time. So finally, let's go over just a couple of questions to ask before firing an employee. Here's a short checklist of things you should ask. Has the employee ever reported anything? We just talked about this. If the employee's reported anything recently, pump the brakes. Don't fire them right now. Talk to an attorney and assess what sort of case you've got on your hands before you fire them. You may need to wait. If they have reported anything, when did they report it and what did they report? If it's recent, again, you're going to need to wait. And if it's something that's protected, especially. If you have questions about if what they reported or what they did was protected or not, again, talk to an attorney before you go ahead and fire them. It does few hours on a phone with an attorney, or 10 minutes on a phone with an attorney, could save you tens of thousands of dollars. What are they being fired for? What's your reason? Do you have a good reason? Is your reason a valid reason? Is it a reason that you can support? Has the employee been given any warnings? Have you had that clear communication throughout this process? Have they had any, is the employee going to be surprised by this? That's another question you could ask. Is the employee going to be shocked? If so, pump the brakes a minute. Maybe you try and give them a performance improvement plan before you fire them. And then, do you have the documentation to support the reason that you're giving them for firing? So, check back through your records. Have you made records of all the performance improvement plans? Do you have records of phone calls, meetings, conversations, Zoom meetings with them, in which you could produce? Imagine yourself in court. Before you fire them, picture yourself standing in court and handing a judge or an attorney all of the evidence that you have that shows that, yeah, they're being terminated for a good reason, and this is a bad employee. We didn't discriminate against them. Think of that stack of paper, go through and find it, and imagine yourself handing that over. How big is the stack? Do you like your evidence? Is it one sheet? Do you only have one memo? Do you have a stack of memos? Do you have a long history of poor performance? Do you have a very short history of poor performance? These are all things that you'd want to figure out before you fire them. Don't just jump into it and fire them straight away and then figure that out later on. So these are all good things to know before you're firing an employee. Obviously, this is an exhaustive list of everything, but it should be a helpful checklist for you if you find yourself in this situation. If you have any other questions, or you're planning on firing an employee, it's always good to call an attorney. I'm here at Beresford Booth. You can talk to any of us. We're happy to talk to anyone that has questions about this. Usually it doesn't take very long to answer those questions, and it can save you a lot of money. So if you have questions, give us a call. Otherwise, we look forward to chatting with you. Thanks.